right, everyone. Thank you for joining us for another great webinar here at Advanta IRA. I'm joined by my colleague, Corey Daharsh, and we're going to be going through the processes and different aspects of utilizing checkbook control within a self-directed IRA today. If you do have any questions, make sure you type those into the question box. All audio has been muted, and we do typically miss like the raised hand. So please just type the question in. Doesn't matter what point it is throughout the broadcast. We'll get to it, even if it's a little bit off topic. The tangents can sometimes be very beneficial for everyone. So again, type it into the chat box, ask the questions. We'll get through them throughout the presentation. So with that said, let's go ahead and get started. My name is Alex Perny. I'm working business development along with my colleague Corey Daharsh. I've been here since 2012. All my contact information is up there. I kind of started my career doing account management and accounting for Advanta. I was involved in a lot of different transactions, but for about the past 6 years, I've been doing new business development, education, and things like that. So I'm really excited to bring you all the information here today, and I think that Corey and I play off each other very well in doing these. So I'll let Corey introduce himself here next.
Yeah, thank you very much, Alex. Everyone, my name's Corey Daharsh. I've been with Advanta for about the past 6 years, just passed my 6-year anniversary actually a few weeks back. I spent the first 5 years with Advanta on the client account management team. So really having a roster of clients assigned to me that would reach out on a daily basis with questions about their account, questions about the rules and regulations, and the intent to process transactions. So I've seen pretty much anything that you could think of from an investment transaction standpoint that can be done within a self-directed account, or even questions about things that cannot be done that I've had to articulate and kind of work with clients through. So a lot of experience between Alex and I on these types of products and these types of accounts, and we're happy to bring some of that information to you today.
Yeah, absolutely. Thanks, Corey. And a little bit about Advanta. We have almost 20 years of industry experience. It's wild to think that we started our business back in 2004. We have a great team of certified IRA services professionals as well as attorneys on staff that can really help to tailor make a service that works best for you. Just a little bit about self-directed IRAs in case you aren't necessarily familiar with it. Although you are doing alternative investments, you're not giving up, but by doing that, you're not kind of giving up any of the traditional securities and assurances that you're used to with traditional banking arrangements like that you would be used to. So everything that's held in our custody as far as cash deposits are FDIC insured. We're proud to announce that we've crossed over the 2 billion asset threshold for value of administrative assets under administration. And every single client that is with us, all 8,000 of them are assigned to a dedicated client account manager like Corey and I both used to do. So you have a specific point of contact that is always going to be married to your account to answer any questions, do all of your investments, and really kind of give you that hands-on personal approach that is so key in doing self-directed investments that you need in order to be successful in getting what you would like to accomplish done. So a little bit about self-directed IRAs. Again, just to kind of build a little bit of a platform, any type of retirement plan that is listed up here can inherently be self-directed. So you don't necessarily have to have a Roth IRA, which is one of the things I run across every once in a while. It's getting less and less, but there is kind of a prevailing thought that you have to have a specific type of an account to do self-direction, or even to do checkbook control for that matter. Any of these types of accounts can be self-directed, and you can use checkbook control within them. So you can do a traditional IRA, a Roth IRA, even SEP simple and employer plans like solo 401ks can be done. And even solo 401ks have other options for doing checkbook control without using additional entities, which is really awesome. And then some plans that people don't necessarily realize are health savings and education savings accounts can also be self-directed as well. So what I want people to understand is that although you are looking at things through a different lens, there is a lot of opportunity to do this type of investment structure with a retirement plan. It doesn't necessarily have to be a Roth or traditional IRA. And let's say you have multiple types of accounts. You can even potentially partner those accounts together on one singular IRA. However, there are some additional considerations with that. But just understand it that if you have maybe buckets of money in a few different types of plans, even if they are different in their tax consideration, i.e. traditional versus Roth being pre and post tax, you can bring those together and invest those accounts as one singular entity and get the purchasing and the buying power of all those funds in one place. So again, just kind of want to build a little bit of a foundation on what types of accounts can be used and to start getting the wheels turning on some potential options that might be available to you for what you're looking to accomplish with the types of plans you have. Now, a lot of people haven't heard of self-directed IRAs. Hopefully you have at least tangentially heard about it if you're on our webinar today, but if not, don't worry. We'll try to kind of demystify this a little bit. These aren't inherently new or exotic types of retirement vehicles. You've been able to do these types of investments since 1975. When ERISA was passed, the Employment Retirement Income Securities Act of 1974, it created IRAs and better defined 401k plans. You've been able to do these types of investments since then. The original legislation gives the custodian broad leeway in exactly what type of assets they will allow to be custodized in the accounts that they hold. Now, it kind of just opened it up for banks to say, hey, you know what, we'll give you stocks, bonds, mutual funds, things that are very easy for people to wrap their head around. And that's where it kind of went. But there was a lot of, again, leeway that the IRS gives onto what you can do with these. Basically, there's a few types of assets that you can't hold, and we'll get into those in a little while. There's some people you can't invest with, but other than that, if you have a custodian willing to hold the type of asset, and specifically to this, if you want to invest in a private LLC or trust or buy things like real estate, precious metals, all these different kinds of things, if you have a custodian willing to hold it, you'll be able to accomplish that. And by best estimates, there's less than 4% of the almost $30 trillion of retirement plan assets in the United States are self-directed. So there's a lot of value out there, and a very small portion of it is done in this fashion, which is why a lot of people haven't heard about it. And again, why we like to put on educational events to help try to bring about that information to the masses so that you can make better informed choices with regard to your retirement plans. If you're looking to get started, again, it's a very easy process. We'll go over this a little bit in the end of it, but just want to let you know it's not an inherently long process. It takes maybe 1 day to get the account open, and then about 5 to 10 business days to get everything funded into your account. In which time we can certainly work with you on getting any type of investment documents taken care of, such as operating agreements, trust agreements, things like that can be reviewed and done. And before I turn it over to Corey to kind of get into the meat of the presentation that we're doing, we just need to quickly disclaim a few things. That Advanta IRA and our employees do not provide investment, tax, or legal advice, nor do we endorse or promote any investment products. All information and materials are for educational purposes only, and all parties are encouraged to consult with their attorneys, accountants, and financial advisors before entering into any type of investment. With that said, I'll turn it over to my colleague Corey, and he'll take over the next little bit on getting through the agenda and what else we're going to be doing today.
All right. Thank you very much for getting us kicked off there, Alex. So everyone, I just want to outline today's agenda so we have a clear path of what we're trying to accomplish here today. So we're going to start with a quick overview of the rules and asset classes for self-directed retirement accounts. And then I'm going to jump into specifically what is a checkbook IRA and how it works, how to set up a checkbook IRA and how to use it once you have it set up for your retirement account investments. And then we'll also cover the process of winding down that checkbook IRA or single member LLC to distribute funds back out for personal use. Maybe you've made some investments and they've panned out well for you and you want to start tapping into that money. We'll definitely teach you how to do that. And at the end, if we have not answered all of your questions as we're going along, we will have a specific slide right before our contact information and wrap up where we'll answer any final questions that are still left there. So as Alex mentioned, please feel free to jot your questions down in the question box. You should see that in the GoToWebinar tab on the side of your screen, and we will take them as we go. So the rules and regulations about self-directed investing are pretty simple when you think of the grand scope of what you're able to do with these types of plans. The only things that the IRS restricts from investment standpoints are an IRA account is not allowed to invest into life insurance policies, collectibles, or otherwise hard to value assets. Anything the IRS would deem to be a subjectively valued asset is not something you should be holding in your retirement account. And also coins and foreign currency. There are some non-circulating coins and non-circulating currency that are allowed to be invested. Those are specific assets that you can either look into more research on our website, or we've done webinars on precious metal investing as well in the past. So check our YouTube page if that's something you're interested in. But aside from those three categories, anything else you could think about that you may want to hold within your retirement account is allowed. Now, the transactions that you do can also be prohibited relative to who you're doing those transactions with. So the IRS deems disqualified persons to pretty much be anyone that is on your lineal tree, whether it's your parents, your children, or your lineal descendants or ascendants. I'll cover that more specifically in the very next slide, but I just wanted to outline that prohibited transactions mean that you're really doing a deal where you're buying or selling with disqualified persons. You can certainly partner with otherwise disqualified persons into a transaction. So if someone's a disqualified person, you can actually partner up with them to make a investment or something along that line. That is allowed. It's really when you're buying or selling from the disqualified person that the IRS really specifically restricts. And the other thing we have here on this slide is just to make sure you're aware of UBIT and UDFI taxes. Unrelated business income tax and unrelated debt finance income are some uncommon taxes that may apply given certain investment strategies and scenarios. If you're interested in learning more, I know Alex has covered a specific webinar on UBIT and UDFI, so you could check that out. We also have a really simple, easy to follow along flyer that we could send you, just a PDF. So if you have interest in learning more, reach out to Alex or I. We'll be happy to pass along some of that information, but I'm not going to get into the tax weeds, if you will, right here and right now on this checkbook control webinar.
Yeah, if you want to nerd out on UBIT and UDFI, I would love to chat with you. It's for whatever reason, I'm the one that always gets those questions, so happy to answer them.
Well, thank you, Alex. I know you've you put a lot of energy into some of the content we've put out there for those topics and strategies, and it definitely, it at the very least has helped me learn as well. So that is some good content. Reach out to Alex if you do have those questions. But circling back to disqualified persons, again, anyone, including your parents, your children, and your spouse, and really yourself, are listed as disqualified persons on your lineal tree. So for example's sake, if you're a real estate investor, you can't buy a house from your parents. You also can't let your children rent a house from your retirement account. So if you own a retirement account or you're looking to buy property in your retirement account, maybe near the college that you're sending your kids to, you cannot let them live there, whether it be rent free or paying rent. That may be a strategy where you buy a house near that college and let your kids' friends live there, or any other non-disqualified person, if that's part of your investment strategy and something you're trying to accomplish. Businesses or entities owned by any of these disqualified persons, either in a 50% or more capacity, or where the disqualified person is making day-to-day decisions for that entity, also falls under the disqualified person's rules. So that's just some things to keep in mind. Again, it's not that complex. It's not that difficult. In most case scenarios, it should not restrict you from doing the investments you want to do. Again, unless of course you're trying to buy your parents' house or you're trying to lend to your children or anything of that nature. So there are a number of different alternative assets you can hold. To put into perspective, you can hold most, if not all of these directly in the name of your retirement account. But since we're talking about checkbook control today, consider these all assets you can hold in the umbrella of an LLC that is wholly owned by your IRA account, or your solo 401k for that matter, health savings or education savings account as well. So a lot of our clients do real estate investing, whether they're buying physical domiciles in the name of their retirement account or investing as a limited partner into syndication deals, but also other investments like private stocks, physical land. You can invest into farm animals and actual movie projects, some real alternative types of assets that not a lot of people are interested in, but maybe you have a specific expertise and you're looking to use your tax sheltered money towards that expertise. There's a lot of options out there. We've actually done a webinar as well on the most unique investments we've ever seen. Our colleague Larissa Green and myself have put that out. I think we've done that 2 years in a row now. So there's definitely a lot of unique things. If you've got something in your mind that you're not sure would fall into the retirement account options or not, reach out to us. We're happy to have that conversation and just kind of walk through your strategy with you and see what works. So when you're talking about checkbook control with an IRA, there are two different real means here to do so. A custodial administrative account really means the administrator retains control of the uninvested cash and processes transactions or expenses and takes in the income. That is what most of our clients do. They'll log into their client online portal and submit anytime they have an expense to be paid, and we process that within the same or the very next business day, so that they're not actually having checkbook control. They're having a custodian administrator, in other words, Advanta, process and hold the uninvested cash for any transactions that need to take place, or again, income or outgoing cash flow. Checkbook control is where we actually fund an investment into an LLC that you establish. So your retirement account in itself makes an investment into an LLC, and you actually set up a bank account that only you and any other managers you appoint have access to, and process all of your investment transactions, cash flow in and out, in the name of that LLC, which carries the tax shelter or the disregarded entity for tax purpose shelter of the retirement account. So the LLC is really the investment vehicle for which you make your investment transactions within. Now, there are a few ways to achieve checkbook control. Some of the common ways are just setting up an actual LLC managed by your retirement account, or trust specifically is also used in some cases, not as often as the actual physical LLC. And then, as Alex mentioned, we do have a solo 401k product, and there is an option with our solo 401k product to inherently have checkbook control without having to establish an LLC. Our do your own, or DYO solo 401k inherently does provide you checkbook control, where you open a bank account in the name of the 401k plan directly without having to establish another LLC after that. Now, investors may choose to establish an LLC for either liability or anonymity protection, but it's not necessarily required in that DYO model that we offer. And kind of the structure here is the duties fall on the manager, which is ideally the client and or someone else that they appoint to be the manager. And the member of the LLC is always going to be the retirement account in itself. So the structure there is pretty simple. We also provide our clients with an instruction email when they want to set up checkbook control that tells them all the specific ins and outs that they'll need to set up. You can also go to a CPA or a tax preparer or a legal professional to get your LLC's documents drafted up and registered with the IRS in the state of your choice. We've got a few referral sources we could point you to if that's something of interest to you as well. So the key components of trusts when you're using checkbook control is the types of trust that's being established. So whether it be a revocable trust, a special needs trust, or a life insurance trust, and the parties to that trust, which are the grantor, which contributes the assets to the trust, meaning basically the retirement account in this scenario, the trustee, which manages the assets in the trust, which usually cannot be the account holder. So there has to be another trustee appointed, and the beneficiary, which is the account holder of the trust or the retirement account holder specifically. When an IRA invests into a trust, the IRA is both the grantor and the beneficiary of the trust, but the IRA owner cannot be the trustee. Again, you would have to appoint a third-party trustee. There are trustee services you could go to if that's something of interest to you. Otherwise, appointing a relative or a trusted friend or someone like that could serve as your trustee for your retirement account. When you're setting up a personal property trust, all you really need to do is set up the bank account, appoint that third-party trustee, and then you have your established checkbook control. When you have a land trust, which is a bit different in structure, they're typically treated like direct real estate. So you do have your third-party trustee. That trustee does have access to checkbook control, but really, again, those trustees in either scenario are going to be the ones that are actually making most of the financial transactions. The cash flow in and out is flowing through that trustee rather than the account holder directly. An Advanta IRA can pay expenses and receive income directly on behalf of the land trust. I've seen those processed plenty of times. We hold the actual land trust as the asset on file in our records, and we receive and process all of the cash in and outflow. Again, we have an online client portal accessible to our clients 24/7. You can submit any requests for payments to be made, and we'll get that payment out the same or the next business day, depending on when we receive the physical request. And the actual components of the LLC, again, the member, which is the retirement account holder or holders, if you're actually doing a multi-member LLC. In general, when we're speaking about Checkbook IRA, we're talking about a single member LLC. but it can be a partnership where you have multiple investors. As long as the ownership percentage is broken down on the operating agreement, that is kind of the threshold there. But in general, when we're talking about checkbook IRA, we're referring to a single member LLC in most cases. The manager, which is either the account holder and or anyone else they may appoint to be the manager of their retirement account, and that operating agreement, which is the overarching body of documentation that says, okay, this retirement account has established this LLC, the members are X and X, the managers are Y and Y. Here is the overall initial contributions, which is usually listed on a Schedule A or a Schedule 1, listing how much money's gone into the LLC at the onset and breaking down the ownership percentage if multiple owners are established. And really, that is the documentation and information we require to establish these things. Now, with this next slide, I know Alex is going to jump into a little bit of the nuanced rules for checkbook control. Again, we do outline most of this for you and discuss this with you when you're getting your checkbook IRA set up at the account manager level.
Yeah, thanks, Corey. All right, so digging in a little bit deeper to the checkbook LLC rules, there is kind of a lot of nuance to this, and one thing I do want to just kind of touch on is something Corey had mentioned, that you can do multiple members in an LLC, but there is some additional tax consideration that you need to be aware of with that. In general, if you have a single member LLC that the IRA is the sole member of, it's treated as a disregarded entity or a pass through, meaning that the entity of the LLC does not have to file any type of tax return. Advanta takes care of all the tax reporting for it. Everything, flows through the LLC to the member. The member is a tax shelter, being an IRA, doesn't have to file a tax return. If you have a multi-member LLC, it no longer can be designated as a disregarded entity. It has to be looked at as a partnership and does have to file a partnership return with the IRS. Now, does that mean you have to pay any taxes? No. If you're just, basically buying stuff and not operating an active trader business, and you're just investing passively into X, Y, or Z, say you bought a piece of real estate and it's just making rental income, you're not going to have to necessarily pay any taxes, but you are going to be under the burden of having to file a return. So it is something that you would need to factor in as far as, what's that cost going to look like? Is that a good fit for me? Should I maybe do two single member LLCs for each of my accounts if I'm, have multiple accounts in order to do that? So it's just something I like to always bring up, because it's not that hard of a jump to say, hey, if I have a single member LLC, well, I could have more money if I had my Roth and traditional invested in here, more money, more good. But you do need to have, again, a little bit of forethought into some additional things that might kind of go on with a LLC if you add multiple members. But with a single member LLC, again, really straightforward. So some rules regarding LLCs and IRAs: has to be manager managed. Now, this isn't too hard of a concept to kind of understand, is that you have the members or shareholders, in this case the IRA, and they have no management duties, meaning that the person that's going to be signing checks, contracts, engaging in any business of the LLC is going to be a named manager. Now, this would typically be the client themselves. You could name a third party if you wanted to. But as Corey mentioned, that the trustee of a trust cannot be the IRA client, because pursuant to IRS rules in 49 internal public, can't talk today, in Internal Revenue Code 4975, you can't act as a fiduciary to an IRA asset, and a trustee qualifies as a fiduciary. A manager of an LLC does not meet the threshold for having to act in a fiduciary capacity. So you can, and this has been examined by case law, that you can act as the manager of an IRA-owned LLC. But you need to keep in mind that you cannot take any direct personal benefit, just like you can't work on a property yourself. You can't buy anything yourself and get reimbursed from the IRA. Same kind of rules all apply to the LLC. Nothing gets obfuscated as far as the rules go when you do a checkbook control structure. Everything applies to the LLC or the trust just as it would to the IRA and you directly. It's just a little bit of a different investment structure. So just keep that in mind, is that all those rules are still going to apply. And then if you do act as the manager of the LLC, that you can't get reimbursed for your services. You can't, reimburse yourself for mileage for driving to the property to make sure a contractor did something correctly. You can't do the work yourself. All those same kind of things still apply, but just keep in mind that because the IRA custodian, in this case Advanta, who's acting as the custodian, is not, overlooking everything, and you are once removed from that purview, granted, it does offer you efficiencies in some administrative aspects, but it does kind of remove a little bit of that safety net, if you will, of us being able to have a trained eye, at least on a very topical level, again, 30,000-foot view level, kind of reviewing stuff to make sure that the easy things are caught. To give an example, I had a client when I was an account manager that went to buy a property in Auburn, Alabama. Easy kind of investment ideal there. He was going to rent it out to college kids. So received we closed on the property, we received a lease agreement, and it had 3 women listed on it, and one of them had the same last name as him. So I asked him, said, hey, who's this person to? He goes, oh, it's my daughter. She's going to start at Auburn in the fall. She's going to rent it. It was a marketable rent. He wasn't trying to do anything inherently, prohibitive or anything. He wasn't trying to cheat the rules. He just, her and her 3 friends were going to rent, be freshmen in Auburn. Well, we saw this and I said, hey, you can't rent it to your daughter. That's a prohibited transaction, up and down in your family tree, as Corey illustrated on that slide. And, unbeknownst to him, he just didn't catch that rule. It was easy enough for us to catch. Unfortunately for the daughter, had to find other living arrangements, but he rented the property out. And as far as I know, he's doing well with it. But let's say in the same scenario, that same, missed rule, that client were to have done checkbook control, he would have signed that lease as the manager of the LLC. And potentially there could have been a big issue for the fact that he rented it to his daughter. So what I like to encourage people, especially with the rules for IRAs and checkbook control, ask the questions now. Always ask us a question. Be very well versed in the rules of IRAs before you start doing stuff with a checkbook control type of structure, because it is much easier to kind of inadvertently commit a prohibited transaction or violate IRS rules with checkbook control just because you don't have, that second set of eyes looking at everything. Now, to get further into it, so you have an LLC or a trust set up. The IRA adds in the money as the initial capital contribution to that LLC. Now, as a single member LLC, the IRA owns 100% of the membership of that LLC. So if you add more money in, you add $1, you add $1 million, it doesn't change the fact that it owns 100% of the LLC. If you were to partner IRAs together in one singular LLC, you add $1 from one, you would have to add the commensurate ratio to the other. So if it's 50-50, you have to add $1 from your Roth and $1 from the traditional. If it's, any other ratio, you always have to add money in the correct ratios in order for those, for those ownership percentages not to change. Your IRAs can't directly benefit each other. Again, just some of the additional small complexities that might be added into this that you need to understand going forward. Because if you have something where you're going to need additional capital down the road, but you don't have maybe a whole lot in one account versus comparatively to the other, then those are some questions that you need to have with us to make sure that your strategy will be viable for what you're looking to do. And again, most of these things can be fleshed out in the beginning, but once you do something and once you fund it, that's when it gets really hard to correct. And it's always, again, best to have these conversations in the beginning. Now, if you're invested in a multi-member LLC and they're non-disqualified parties, so, let's say Corey and I decided to invest our IRAs into an LLC and I wanted to add in more money and he didn't, yeah, we have no relation to each other. Our IRAs, you could change the percentages. It wouldn't necessarily be an issue. But again, if it's your 2 LLC, if it's your 2 IRAs, or if it's you and a disqualified individual's IRA, so husband and wife, or let's say spouses, or you and your child or something like that, that's when you need to be really cognizant of some of these rules down the road, because again, they can definitely offer some issues down the road. Now, another thing that people like to look at for LLCs is that, yes, in the name, limited liability company, they think that inherently having an LLC, especially in real estate, LLCs are extremely popular. But one thing personally that I just don't like is they're popular without the underlying education that goes behind it. They get kind of pontificated about by saying, hey, protect yourself from liability. If someone slips and falls, they can't come take your house and all of your other assets. While in certain contexts that might very well be true, it's important to understand the nuance, because with LLCs and law, nuance is everything. So in general, a single member LLC is not going to automatically factor in that type of good ancillary asset protection that most people preach on this kind of thing. Especially in the state of Florida, typically a single member LLC is seen as a pass-through for liability purposes, or for any type of action that is generated by the ownership of an asset. So partnerships typically, start to have that factored in a little bit more. But the downside to this is that LLCs are legislated on a state level. So there is 50 different flavors in the United States of laws that regard liability and asset protection with LLCs. Are we going to get into all 50 today? Absolutely not. We definitely don't have time for that. I don't think y'all would want to stick around for it. But if you're looking to do an LLC and asset protection is a question that you would like answered, check with an attorney. And paying for a couple $100 of an attorney's time to ask those questions and get a real backed up answer is cheap insurance. Paying a couple $100 to an attorney to get a real answer on which route you want to go to get the types of protections you may want or need is, the ounce of prevention is worth thousands of pounds of cure in this case. So I always encourage people, yeah, attorneys are expensive, but when you're talking about your retirement plan, especially with liability issues, talk to the real professionals. Now, with regard to case law that is kind of establishes the ability for you to do this kind of thing for an IRA to own an LLC or to own a trust, there's two big cases that people like to point to. Swanson v. Commissioner of 96 and the tax court memo of T.L. Ellis from 2013. Basically, these two cases have examined in tax court the structures of people doing different things with IRA-owned LLCs. And both times, although Swanson v. Commissioner, Swanson won, and then oddly enough, Swanson actually sued the IRS to recover court costs, which I would maybe say was a bad move to maybe get audited for the rest of your life. But he won that case, and the details, you can look it up. The tax court memo of T.L. Ellis, I think, is a little bit more interesting in how it examined what went on. They tax court specifically said they did not have an issue with the structure of the IRA owning an LLC. However, Ellis did lose that case because he was paying himself a salary from the LLC. So they had issue with the fact that he paid himself from the LLC personally, but the fact of the structure of how everything was run or him acting as the manager in general wasn't an issue, just the payment. So again, tax court stuff comes out all the time. We try to stay very well abreast of it. There's been different court cases recently, even with this one was the McNulty case that originated just recently that was settled, where again, the IRS did not have an issue with the inherent structure of the IRAs owning LLCs. In this case, it was a husband and wife that owned a that were partnered on an LLC. They had bought precious metals and they decided to store it in their home. Now, that was an issue because they took direct personal access and had unfettered access to an IRA-owned asset, which was the issue. They lost that case. But again, the IRS did not have an issue with the LLC ownership. It was how they administered the assets. So again, sound a bit like a broken record, but always check with us. Do your research. Consult with the experts and the people that understand this, so that way you don't necessarily run into an issue where otherwise they bought the gold, that wasn't an issue. It was how they stored the gold that was the issue. So again, easy things to kind of not have an issue with, but they did because research wasn't done. Okay, forming a checkbook LLC. Now, with regard to a LLC, there's several different pieces of this. Now, a lot of people say, "Oh, well, I just went to my state's website and I registered my LLC." That's not what we need. You need to certainly register with a particular state and get what's called your articles of organization, which essentially in that particular state shows, hey, John Smith has an LLC that's titled X. You do all of that personally. The IRA does not go on that. You're just registering, as the manager or the interested party saying, hey, state of Florida, I want to have an LLC, and the cost to do that's going to vary. I think the state of Florida is like $170. If you go to states like New York, Illinois, California, they're going to be real expensive. Now, you don't have to use the state that you live in. You can register the LLC for the IRA in any of the 50 states. Again, they all have their own flavors and reasons why people like them. I tell people typically, unless there's a specific reason you need to use something in those states or places like Wyoming, Nevada, get a lot of press. I would use a state that is cheap and has relatively easy annual reporting requirements, because with an LLC, you have to do an annual report to that state to keep it in compliance. The last thing you want to do is have a non-compliant LLC on the state level and have issues just on the LLC, not with the IRS, but with the Department of Revenue in a particular state. So making sure that you can keep that LLC current and registered and not be paying an exorbitant amount of money is very important in this whole thing, to make sure that you're just not getting eaten alive by fees. But you have to file that articles of organization. You also have to obtain a tax ID number. So the LLC has to file form SS4 with the IRS to get a tax ID number specifically for that LLC. Now, You can do this online. Again, most people do it themselves. It's pretty easy, or the person that you pay, or if you go with a service provider to draft the operating agreement for the LLC, that can, they can certainly probably provide that as part of a service package that they have. But you need to have kind of three basic things as far as paperwork goes in order for an IRA to invest in an LLC. You got to have the articles of organization. You got to have a tax ID number, so you got to apply for that, and then you also have to have an operating agreement. The operating agreement is kind of that outlier that if people that have set up LLCs in the past may not have done, because just to register with a state, you don't have to have one. So an operating agreement, which is what details the IRA as the member, details the management being manager managed, and details any additional members as well. That is what needs to be provided. And typically that's the crux of why people typically go with the service provider, because that is a formal legal document. And although you can find, you find anything online, but if you get one online, your mileage may vary with how well it's put together. And if you do ever have to go to court, having something that is well done and backed up by a qualified service provider is probably good. And then opening a bank account. Once you have the articles and your and you have the tax ID number for the LLC, you can open up the bank account. And then at that point, the LLC is kind of ready to be funded by the IRA. Okay, filing the articles. Most states require that LLC or LLC appear in the name of the LLC. You can name this LLC whatever you want. I would encourage you to, be relatively professional with it. The IRA should not be in the name of the LLC. That goes on the operating agreement. That's just the name of the shareholder. So you don't name this one like Advanta IRA for benefit of John Smith IRA LLC. Do not do that. We've had clients do that. It is a nightmare. So do not do that. You have to have a registered agent. Each state requires you to have a person available to receive legal notices. And the registered agent must be physically located in that state. So if you are registering an LLC in a state outside of where you live, you can act as the registered agent of the LLC. But if you're acting outside of that, you need to pretty much, most people just engage a registered agent service. They're in every state. They charge, a nominal fee per year to act as the registered agent in that state. And then the management in the articles must name a manager. So again, you don't have to live in the state, but the articles is where you're going to name yourself as the manager or the interested party and signatory of the LLC. Again, that's what you walk into the bank with your articles and your tax ID number in order to open up that bank account. And with an IRA LLC, you cannot have managing members. So sometimes on the articles, you are required to list shareholders. Very rarely in most states do you have to do that. But keep in mind that when it asks for managers or management on the articles, you have to indicate that it is managed by a manager, not a managing member. Because remember, the IRA is going to be the member of the LLC, not a managing member. Because if we were the managing member, then Advanta would have to sign everything, review everything, and you would get away from having checkbook control. So creating the operating agreement. So an operating agreement lays out how the LLC will be run. It's kind of intuitive in the name. Operating agreement is what everyone agrees is how everything's going to be operated. Attorneys and CPAs, can typically always do this. You can use places like LegalZoom. There's really no right or wrong way to go about it. I typically encourage people, while yes, you can use an online service like LegalZoom, once you kind of finish it, if there's, let's say, a spelling mistake or something that needs to be corrected once we review it, getting a company like LegalZoom to correct something or amend something can be an absolute nightmare. So maybe paying a few extra bucks to have someone with a pulse on the other end of the line that you can go to and get, like if it's, let's say, a member managed operating agreement, maybe you click the wrong button, maybe they made a mistake. Getting, again, like a LegalZoom to fix that is very difficult. If it's a person on the other line, yeah, easy enough. They correct it, send it back to you, sign, done. But at minimum, the operating agreement needs to include the following: an effective date of the agreement, so it has to be dated, can't be open-ended. It needs to name the members, which is going to be the self-directed IRA. It needs to name the managers, typically going to be the account owner. It's going to detail the limited liability of the members and managers. It's going to detail how new members may be admitted to the LLC. It's going to detail how members can be removed from the LLC. It's going to state the taxation of the LLC. Again, this is typically going to be taxed as a pass-through. It cannot be taxed as an S-Corp. That's one important thing. You cannot tax this LLC as an S-Corp because an IRA cannot be the shareholder of an S-Corp. So you can tax it as a pass-through, tax it as a partnership. You can tax it as a C-Corp if you wanted to, but typically people don't, because then you'd be electing to pay taxes on all this great tax-sheltered money. and then it has to have a signature of all the members and the managers. A few other things. The operating agreements can also include termination of the agreement. How to address disagreements among members and managers. Typically, since a IRA can't speak, you're not going to have an argument with the manager and the member. But let's say you no longer want to manage the LLC and you get someone else to do it. It's important to maybe have some of, again, that forethought to say, hey, if I have a disagreement with someone, how does this get fleshed out? You detail it in the operating agreement. How to remove managers, rights of first refusal, buying, selling, which governing law is going to apply to the LLC, and arbitration clauses as well. So again, these are just some of the high level things that can be included in an operating agreement. And we've had people do their own. Do I recommend that route to go? Not necessarily, but again, if you understand this enough and you can do enough research and you feel comfortable in doing X, Y, or Z for your IRA, typically that's not too much of an issue as far as this stuff goes. But I do encourage people to have a professional CPA attorney. There are online services that you can use for legal advice for these kind of things. Have someone competent to do this, because at the end of the day, this is going to be something that can affect your entire retirement plan. And do you want to have something as innocuous as paperwork be a big issue for you? I would think not for most people. So again, that's kind of what I have to say on the operating agreement side, the little bit more of the technicality stuff on how they're set up, what you need to do, the operating agreement, the details that go into that. And with that said, I'll turn it over to Corey for the next block of slides.
Yeah, thank you, Alex. And before I jump into maintaining the checkbook IRA, I do want to address a commonly asked question that I get. I actually answered this question twice this week. If you have an LLC that you may have established and just never actually utilized that LLC for any purpose, meaning it's never had a bank account established, hold cash, never actually served a physical purpose above and beyond you getting it registered with the state of your choice and with the IRS for a tax ID number, you can amend the operating agreement to qualify and satisfy these rules that Alex just laid out and utilize that LLC for your checkbook control. However, if that LLC has ever served a purpose, been utilized for any outside activity aside from the intended retirement account investment strategies, then you would have to set up a new LLC and form it all from scratch at the onset. So it's just a common question that I get. A lot of people, for one reason or another, may set up multiple LLCs at some point and just not utilize all of them. So just to kind of get out ahead of that question and answer that for you guys, if you've got one laying around, as long as it's never served a purpose or held personally controlled money, it can be repurposed for the checkbook control strategy. Now, maintaining the checkbook IRA once you actually have it set up. So let's look at an investor that has already established the LLC, established the operating agreement, a bank account, worked with their client account manager to invest their retirement account into the LLC. Well, then you've got the money at your discretion, at your ready. You have either a checkbook control or a specific debit card that you're processing investments with and making your asset transactions with. All of the cash flow of the investments you make need to go directly in and out of that LLC's bank account. And it's also your responsibility to maintain proper record keeping and bookkeeping of the LLC's actions. So as Alex mentioned, you don't necessarily have the safety net or the big brother, if you will, of Advanta to have those records on file, because we do not inherently have access to your bank account or those records. That is completely on you as the account holder when you set up checkbook control to maintain those things in the event that you're ever audited in the future. You must, at a minimum, just report your value to us annually. We typically, at the beginning of November, which is coming up next week, send out a request for our fair market valuation. And really, it's a simple one-page form where we just need to know the grand total of what your LLC is worth as of a specified date. You sign it, send it back to us, provide a spreadsheet if you'd like to, or any other supporting documentation. And that's what we report on file on our end and further report to the IRS. Now, it's not that the IRS needs that for any explicit or direct capacity above and beyond just maintaining their rules and regulations on how they plan to change any potential rules in the future of what they're managing through these retirement accounts. So it's a simple reporting mechanism. It's not necessarily making any change at this point in time as to how they're affecting the control of these retirement accounts. And again, the earnings of the investments you make must stay in the LLC until you want to use them for another investment outside of the LLC or utilize them for any personal purpose or capacity. So as Alex said earlier with the disqualified rules when he was covering that, you can't pay to fly yourself to a property you own out of state, or any other personal compensation. If you want to utilize any of this money for personal purposes, you would really need to send the funds back from the LLC's bank account to Advanta directly to either invest into other assets outside of your LLC or execute a distribution transaction, which we would report to the IRS per the distribution protocol. So it really just is very important that this money is flowing directly through the LLC's bank account. There's never money being taken out for any personal purpose or money deposited into your personal bank account for any purpose or capacity outside of the checkbook controls investments. Now, your LLC can partner funds with other IRAs or other individuals. So multiple parties can partner on real estate or other investments. When an IRA partners with an LLC, it must receive the appropriate share of income and expense, just like Alex outlined for the actual LLC setup. So if you want to use your LLC to invest in a piece of real estate, and your LLC is going to own 50% of a $100,000 property, and John Doe is going to own the other 50%, well, you both should be sending $100,000 to the closing table, plus or minus closing costs, obviously. And then moving forward for that investment property, if there's any other expenses, let's say a roof needs to be redone or you need to put in new flooring, whatever dollar amount that invoice is must be paid at that ownership percentage that's broken down on the deed of title of the physical piece of property. I'm just using property as a simple reference. Any other asset that you may invest into is going to follow the same protocol here with the ownership percentage respect to the dollar amount that's brought to the table when the initial investment transaction takes place. When multiple parties are involved, an LLC can make managing the investment less cumbersome. The LLC can kind of serve as the overarching entity, and all of the members within the LLC can just be pooled together with their resources so that the property is owned in the name of the LLC instead of in the name of the LLC for X% ownership plus John Doe for X% ownership and maybe Jill Doe at Y% ownership. So it does make things potentially a little bit more consolidated and less cumbersome. Again, that really depends on a user by user basis on their structure. We're here to talk through some of those strategies at the account manager level. And then obviously you want to refer to your own legal professionals, tax professionals, whatever financial or fiduciaries that you have in your life guiding you through your due diligence process. The manager of the LLC will hold all of the investors' funds and make the investments on behalf of the LLC. Again, usually that's going to be the account holder. You may appoint a secondary manager above and beyond yourself as the account holder. It's very seldom, if not never, that I have seen a manager that's listed who is not the account holder and the account holder is not listed in any management capacity. So I have seen a secondary manager brought in, but I've never seen a secondary manager be the only person listed on the LLC's operating agreement in management capacity. And then use caution when you're partnering with disqualified persons because the capital cannot change. And if you are only able to bring new money to the table at a specified ownership percentage and one of the owners doesn't have any more money to bring to the table, well, you may be locked out of making that next advancement into the investment property. So if you need $10,000 more to put a new roof on a house, and you own 60% and your partner owns 40% and he doesn't have $4,000 to put into the LLC or to put into the property, your hands are tied until he has the ability to make that equivalent compensation. You can't exchange ownership percentage with a disqualified person, so there's no way of kind of making any adjustments to the investment structure. It really is just a waiting game until that person or persons or entity has the ability to make their appropriate contribution based on the ownership percentage split. So moving cash from the LLC or trust, it's pretty simple. Again, the LLC sends the funds to Advanta as either dividends or income. We have a real simple deposit coupon that you can utilize for that. Unless we're liquidating the LLC completely and closing it out, that's all it is sending the funds, whether it be a check, an ACH, or a wire back to Advanta. Our client account manager can provide you a wire or ACH instruction letter on our letterhead to provide to your bank. Usually that's provided when you set up the LLC and you're getting your first investment transaction funded. But if you're an active client of ours that just doesn't have access to your retirement accounts funding instructions, go ahead and reach out to your account manager. They can send that to you pretty quickly and efficiently. The Advanta account makes the deposit. You'll receive an email notification the day that deposit's made. And from there, you can send a distribution form in. You could initiate a distribution request via your client online portal. And we process that transaction or that distribution and issue the appropriate 1099, which reports to the IRS that you've made a distribution out of your retirement account. So it is very important that you do any distributions through this capacity. If you take personal money out of the LLC without utilizing this, it's not going to be properly reported to the IRS. And furthermore, it really becomes a prohibited transaction or disqualified transaction for you to have pulled that money out of the LLC account directly for any personal purpose. So we're really stressing that you make sure you're aware of these rules, that you do that appropriately. Again, as Alex mentioned, without the safety net of Advanta and with checkbook control, you do have the potential to make these hiccups or missteps, if you will, if you're not listening thoroughly to this or not well aware of these types of rules and regulations. So the pros and cons of buying through an IRA directly. The pros of buying through an IRA directly is that it's easier to keep from arm's length from the IRA funds. Advanta IRA, as the custodian administrator, is handling all of the transactions, handling all of the cash flow in and out. So you're never in a capacity to ever take personal possession of the money or do anything potentially prohibited with the money of your retirement account. And it also creates a clear record of all activity in and out of your account. We notify our clients via email, and they always have access to review statements or request specified statements through their online portal or through their client account manager. So it's really a little bit more documented record keeping that we're doing when you're managing an asset directly through the IRA. And the cons, you're maybe charged a bit more administrative fees when you have multiple assets and you don't have the ability to write checks for immediate purchases. So just for example's sake, if you're someone that likes to go to tax deed and lien auctions, we can certainly facilitate tax deed and lien investors directly through an IRA purchase. It's a little bit more cumbersome in that we typically have to cut a cashier's check ahead of time for the maximum amount you're willing to spend at the auction, and we send that check to you for you to go to the courthouse or go to the online tax deed and lien auction. Whereas if you had checkbook control, you have the access of that bank account, of a debit card or a physical checkbook in your hand to make those types of transactions. So if you're a hard and fast investor that really tries to get things done either at the last minute or on a quick capacity, maybe buying directly through an IRA is not specifically for you because of the speed in which these transactions occur. Now, having said that, I do want to address that our account management team is pretty quick. We can get a transaction turned around usually within 1 to 2 business days. But again, if you're trying to do a tax deed or lien investment, or you're a real estate investor and you're going after maybe some distressed properties and you've got to have cash in hand when you make an offer, it just may not be as quick or as advantageous for you as checkbook control will be. And the flip side of that, the pros and cons of using checkbook control is you have that quick access to the IRA funds if you're going to auctions or you're wheeling and dealing, if you will, on some transactions where you may have a gentleman's agreement and a handshake that needs to be followed pretty immediately with an exchange of funds. The checkbook control is going to be your best entity or best access point to do so. You can hold multiple assets within your LLC, all under the LLC's bucket or umbrella, if you will, and be charged less administrative fees by Advanta because our fee agreement typically is based on the total number of assets you hold in your account. And on our records, the LLC may be the only asset, and everything you invest into within the LLC is all just encompassed within the LLC, and we're not doing any additional work for it. Therefore, we're not charging any additional asset maintenance fees for those entities. And then there's the also ability for anonymity or asset protection that you do get by having that LLC set up. I know Alex mentioned earlier, it may be something to speak with your CPA, your tax preparer, a legal professional about what type of anonymity and asset protection does come with those. If it qualifies or satisfies your needs and your intentions to set up the LLC, then that's obviously a route you may want to go. The cons are that you're more responsible for record keeping. Again, keeping those accurate records of the cash flow in and out, the investment transactions that are taking place, documenting all of that through proper bookkeeping and record keeping protocols, just in the event you may ever be audited in the future. There's lack of oversight by Advanta. So if you're not circling back with your client account manager and asking questions about potentially prohibited investments or transactions, then we're not there to guide you and advise you on what you could or could not be doing wrong. I know Alex gave his example of the Auburn investor with the daughter that was going to be a tenant. I have a number of similar scenarios and investments that have taken place through checkbook control clients or non-checkbook control clients where I really was able to save them hassle and headache just by having a simple conversation. I liked in my days as a client account manager being able to walk through scenarios with my clients, and it helped me learn how people are investing and for my future own personal investment purposes. And it also helped me better understand these rules and these regulations that I'm here to guide my clients on. So that is what our account management team is there for. We try to boast that we have the best, if not one of the best, customer service teams in the industry. And we really do so by helping our clients and keeping on top of what these rules and regulations are. And again, it could be easier for you to engage in prohibited transactions if you're not utilizing the resource you have at hand with our account management team and with our team in general, with all this educational content we're putting out. So what is the best strategy for you? Again, consult with your advisors, do your due diligence. We can provide you references, whether it be a reference to set up the LLC, a reference to a CPA or a bookkeeper type individual, or even a reference to financial institutions that are familiar with setting up these checkbook control bank accounts, whether it be the solo 401k bank account directly or the bank account for an IRA owned LLC. We've got resources for you. We're happy to provide them to you. It's really something that we try to help everyone make this as smooth and simple of a process as possible. Most clients typically do choose just to have Advanta hold the assets because they have that additional protection and the additional buffer of our oversight and our professional expertise in what we're doing. And it's also possible to switch between these strategies later on. It may require a quitclaim deed or assignment of ownership interest in the assets, but you can set up an LLC now and decide to wind it down and still hold those assets in your retirement account directly, or vice versa. You could make a number of investments directly through your Advanta account and then decide, hey, I want to consolidate these for one reason or another into an LLC. That's perfectly fine. That's a strategy we've done both directions plenty of times, and your account manager can help you through that process. Advanta IRA is not able to provide counsel or advice, so we'll talk you through the strategies. We'll answer any questions you have, but it's ultimately your final decision to jump between the LLC strategy and the non-LLC utilizing strategy. From a real middle of the fence position, we can answer your questions. We can help to that effect guide you, but it's ultimately based on that conversation or the conversation with your CPAs, attorneys, that you make the decision yourself with your own due diligence process and your own further action and thoughts in mind. And Alex, I will hand it back over to you for our key takeaway points and to wrap it up.
Yeah, great. Thanks, Corey. So the points that we really want people to take away from this are is a great strategy for many self-directed investors, but you really need to kind of look at it holistically of seeing if this is actually going to be a good fit for you. Just because you do some research and say, hey, I really like all of this. Is this going to be great for me? And I'll give an example of when I had a client that it wasn't necessarily a good fit for her, but she thought it was going to be, what she really needed. She was looking to buy a condominium at a 55 plus community, allowed rentals, had built-in property management, and already had a long-term tenant. And she came to me. We opened the account, and she was looking to do a checkbook control LLC. Now she wanted the ability to write checks. She thought all of that was great, and I kind of looked at it with her. I said, hey, you're going to be paying a state registration fee as well as Advantage fees, as well as, a couple $100 to have this LLC set up. When in reality, the property manager is going to be taking care of, doing any small repairs. They're going to be probably the ones signing the lease. So some of the inherent benefit that you thought you might have had is kind of lost. And she ended up not going with the LLC route, saved some money, and was perfectly happy. So just think that, checkbook control, if you really want it, we're not here to say that's a bad reason. Personal preference, be what it is. whatever makes you the most comfortable there. Just understand that the benefits of this aren't always going to be as pronounced as you might think they are. It's always best to have a conversation, kind of like Corey said, just have the conversation, see if this really works out. So it's a great strategy for many investors, but not all. There are specific considerations for setting up either an LLC or a trust. Again, a lot of people go with the LLC. I'm not going to sit here and tell you otherwise, but there are other options. Trust are a significant minority of people that we do checkbook control for. And if you have a solo 401k, there are ways to accomplish checkbook control without having to use any type of additional entity, which is really cool. But sometimes people want to go the LLC route. Again, personal preference be what it may. There are options there for you as well. And once it's set up, you can use these funds for anything that you need, but you can't use it for personal use. But if you do want to have personal access to the money, it has to be distributed in the proper mechanism like Corey illustrated with that. Now, if you want to have any more information or you'd like to reach out to us, we have a lot of good information out there. We have bi-weekly seminars, webinars, we have networking events. We also have a weekly podcast that we put out there with a bunch of great guests on various different topics. We have a video library of everything you see here. So if you want to go back and review what we had here today, go on our video library, easy enough to look through. And we also maintain an up-to-date blog. With that said, if there are any questions, we are here to help. Our contact information is right up here on the page, just a little bit after the top of the hour. We do appreciate all of you being with us today. So if there are any questions, please feel free to fire those off. If not, we'll go ahead and get this thing buttoned up here in a few moments. Again, thanks, Corey, for doing this with me today. I always enjoy doing these with you. I hope everyone got some good information.
All right, thank you very much, Alex. Appreciate your time and efforts as well. I do just want to reiterate, we do have a video library. This webinar in itself will be posted to our YouTube channel within 24 to 48 hours of the live recording here. We try to put out 2 webinars a week, usually every Tuesday and Thursday, 12 p.m. to 1 p.m. Eastern time. Every other Friday, we have a virtual networking exchange called Pitch, Promote, and Prosper. We did just do that last Friday. So next Friday, November 4th of 2022, you'll be able to network with our investors, say who you are, what you're looking for from an investment standpoint, or what you have to offer, and exchange contact information and network further from there. And then the Alternative Investing Advantage podcast, hosted by Alex Perny, is a weekly podcast that you can check out with great guests, great expert information, not only from Alex, but from our network that we have built of investment providers, of experts in the industry of retirement account investing and investing in general. So check it out if you have interest. It's a great resource.
Yeah, our guest this week was a very interesting guy named Brandon Cody. He was talking about how to make successful entrees into investing as a limited partner into apartment buildings and commercial real estate, but mainly focusing on just the beginning aspects of it and how to do it. It was a great conversation. I'd encourage you to check it out. With that said, it looks like we have a lot of people kind of dropping off, no real questions coming through. So I think we can probably button it up here. Again, the recording will be out there here in a little while. Again, thank you very much, everyone, for joining with us today, and we will see you on the next one. Thanks.